Welcome, everyone, to today's discussion on ADR international enforcement. During this presentation, John and I will guide you through the key elements outlined in our help sheet covering the legal frameworks, practical challenges, and emerging needs in enforcing international ADR agreements. So let's dive in. John?
Thank you, Walter. So let's start with the very basics. What exactly is alternative dispute resolution, or ADR? As outlined in your help sheet, ADR includes arbitration, mediation, and conciliation. These are non-judicial pathways that offer flexible, private, and efficient ways to resolve disputes. ADR is particularly valuable in international contexts where preserving business relationships and accommodating diverse needs are critical. For example, arbitration awards are binding, while mediation and conciliation focus on voluntary agreements tailored to the parties' needs. UNCITRAL's model law, which stands for the United Nations Commission on International Trade Law, sets forth global standards for arbitration, ensuring consistency and fairness. For additional information, the UNCITRAL website offers a wealth of resources.
John, that's a great explanation of ADR in general, but I think our audience might also like to hear more about why ADR is particularly advantageous in international disputes. What makes ADR a better option compared to litigation in cross-border cases?
That's a great question, Walter. ADR in the international arena really stands out because it offers flexibility, which is essential in cross-border disputes where there are cultural, legal, and linguistic differences that can really complicate litigation and increase tensions. ADR allows the parties to select arbitrators or mediators with expertise in specific industries or expertise in a cultural context, leading to more tailored outcomes. Additionally, arbitration awards are enforceable globally under the New York Convention, which reduces the risk of unenforceable judgments, a common issue in international litigation. Adaptability and enforceability make ADR particularly appealing in multinational businesses.
Thank you, John. And it's also worth emphasizing that ADR's flexibility allows for creative business focused solutions, a significant advantage over litigation. Now, let's move to the benefits ADR provides in the international context. One of the standout benefits of ADR is its efficiency. Compared to costly litigation, ADR offers faster resolutions, a critical factor in cross-border disputes. ADR also ensures cultural sensitivity, accommodating diverse backgrounds and reducing the potential for misunderstandings. Another key advantage is confidentiality, as emphasized in the International Center for Dispute Resolution, or ICDR, international arbitration rules, notably Article 37, which protects sensitive information disclosed during proceedings. As the International Division of the American Arbitration Association, or AAA, the ICDR ensures impartial and effective administration of cross-border disputes. This confidentiality is particularly valuable in industries like technology and finance. The help sheet also highlights the cost effectiveness of ADR as illustrated in the AT&T Mobility LLC versus Concepcion case.
Walter, thank you for that overview of ADR's benefits. Our audience might be curious about how ADR addresses cultural differences in cross-border disputes. Can ADR really handle these challenges efficiently?
Absolutely, John. Cultural misunderstandings are often at the heart of disputes, and ADR provides a platform where these nuances can be addressed constructively. Mediators and arbitrators experienced in cross-cultural cases can bridge gaps by understanding cultural norms and communication styles. For example, in mediation, parties can openly discuss their concerns in a less adversarial setting, which reduces the potential for conflict escalation. To maximize these benefits, Parties should consider including culturally aware neutrals in their ADR process and using interpreters when language barriers exist.
Very good point. ADR's ability to save time and money while maintaining confidentiality and preserving important business relationships makes it an invaluable tool in international commerce. Now let's turn to the legal frameworks that underpin ADR enforcement globally. And if you would please turn your attention to column 2 entitled Legal Frameworks for ADR Enforcement Globally. And please take a look at box number 3 entitled New York Convention Overview. As you probably know, the New York Convention of 1958 is the cornerstone of international arbitration enforcement, with over 170 signatory countries. The New York Convention ensures that arbitration awards are treated as binding and enforces them under Article 3 of the Convention. Article 5 of the Convention provides limited grounds for refusal to honor arbitration awards, such as public policy violations. For instance, the Parsons and Whitmore case demonstrates how narrowly public policy is interpreted, preventing its misuse and promoting consistency in enforcement globally. And here's a valuable tip. Parties and counsel should ensure their arbitration agreements meet all of the formal requirements of Article 2 to maximize the convention's benefits.
John, that's a helpful summary of the New York Convention. But I think our audience might also want to dig a little deeper into the enforceability component. What are the most common reasons a court might refuse to enforce an arbitration award under the New York Convention?
Well, the most common grounds for refusal include invalid arbitration agreements, often because the agreement doesn't comply with the formal requirements of Article 2, or procedural irregularities like improper notice of arbitration. Public policy violations are another reason, but courts have interpreted this very narrowly, as seen in the Parsons and Whitmore case. To avoid these and other pitfalls, parties should absolutely ensure their agreements meet the convention's formal requirements, documenting the proceedings meticulously, and only selecting jurisdictions with a strong track record of enforcing arbitration awards.
And for anyone interested in diving deeper, the New York Convention's official site offers a wealth of comprehensive resources. Now, let's discuss other important enforcement mechanisms which are addressed in box 4 of your help sheet. Beyond the New York Convention, the ICSID Convention, which stands for the Convention on the Settlement of Investment Disputes between States and Nationals of Other States, governs investment disputes and emphasizes state compliance with arbitral awards. As highlighted in the Chevron Corporation versus the Republic of Ecuador, the ICSID framework provides robust protections for investors. Regional conventions such as the Panama Convention offer additional frameworks tailored to specific regions. These mechanisms complement the New York Convention, ensuring a global system for arbitration enforcement.
Walter, knowing about these additional enforcement mechanisms is certainly helpful, but our audience might wonder how the ICSID Convention stands out compared to the New York Convention. Can you give us an overview of some of the key differences?
Absolutely. The ICSID Convention is unique because it focuses specifically on investment disputes between states and foreign investors. Unlike the New York Convention, which requires parties to seek recognition of awards in domestic courts, ICSID awards are automatically enforceable as final judgments in member states. This streamlined process is a significant advantage for investors. But to benefit fully from this feature, parties should ensure their investments fall within the scope of the ICSID Convention by carefully drafting arbitration clauses and confirming that both members are members of ICSID.
That's a really important point, Walter. The enforceability of IC/SID awards, which are automatically treated as final judgments in member states, is a significant reason many investors prefer IC/SID arbitration. And with that in mind, let's shift our focus to the practical challenges in enforcing ADR agreements. And I'd like to turn your attention to page 2 of your help sheet under the column entitled Practical Challenges. I'll address the cultural and legal barriers to enforcement as listed under box 5 of the help sheet. Now, enforcement challenges often arise due to differing legal traditions and public policy exceptions. For example, in Dahlia Real Estate versus Pakistan, the United Kingdom Supreme Court refused enforcement due to jurisdictional issues, highlighting the importance of clear arbitration agreements. To address these challenges, it's crucial to draft precise arbitration clauses and to include specific choice of law provisions. Resources like CIARB, which stands for the Chartered Institute of Arbitrators, provide templates and best practices to enhance enforceability. And while cultural and legal barriers can be daunting, taking proactive measures like engaging local counsel and choosing arbitration-friendly jurisdictions can really help mitigate these risks.
John, I'm sure that our audience would like to know more about how parties can proactively address these challenges in their ADR agreements. What proactive steps should parties and their counsel take?
Excellent question. First of all, parties should include clear arbitration clauses in their contracts, specifying the location for arbitration, applicable rules, and the governing law and jurisdiction. For example, a well-drafted clause might specify ICC arbitration in a jurisdiction like Singapore, known for its arbitration-friendly legal framework. Second, engaging local counsel early can provide valuable insights into both legal and cultural nuances. Finally, parties should consider investing in cultural training for their teams to ensure they approach negotiations and arbitration proceedings with sensitivity and understanding.
And with that in mind, let's move on to overcoming enforcement issues. Please direct your attention to box 6 on your help sheet. Overcoming enforcement issues requires careful planning and drafting. Best practices include drafting clear arbitration clauses and choosing venues recognized under the New York Convention, as highlighted in the Fiona Trust and Holding Corp versus Privalov. The House of Lords established a pro-arbitration approach, stating the construction of an arbitration clause should start with the assumption that the parties wish to have their disputes resolved by arbitration. Legal precedents can also play a vital role. For example, in Dahlia Real Estate and Tourism Holding Company versus Pakistan, the court ruled that enforcement was denied because the government was not a party to the arbitration agreement, a specific requirement in that jurisdiction. Similarly, in Misco Inc. versus United Steelworkers, the United States Supreme Court emphasized that courts may not refuse to enforce arbitral awards merely due to disagreement with them.
Walter, I imagine some of our audience might be asking how they can prevent enforcement issues from arising in the first place. What would you recommend from a practical standpoint?
That's a good question, John. Clarity. Prevention of enforcement issues starts with clarity. Drafting precise arbitration clauses is essential, including defining the scope of arbitrable issues and the applicable procedural rules. Selecting a reputable arbitration institute, such as the ICC or the LCIA, can also provide structural safeguards. Additionally, choosing jurisdictions that are signatories to enforcement conventions, like the New York Convention, minimizes the risk of non-enforcement. Finally, regularly reviewing your client's arbitration agreements and updating them as laws evolve is another best practice for avoiding future disputes.
The Fiona Trust, Dahlia Real Estate, and Misco cases really underscore the importance of precision in arbitration agreements. Resources such as the International Council for Commercial Arbitration, or the ICCA, that website and its contact points provide valuable guidance for practitioners. Anyone involved in this area should be intimately familiar with the ICCA and take advantage of their numerous resources. Now, let's delve into some notable cases that help illustrate these principles in action. Please direct your attention to column 4, box 7 of your help sheet entitled Notable Case Studies. The first notable case is Yukos International Limited versus Russia, where a $50 billion arbitration award was invalidated by Russian courts, citing procedural violations. This case really demonstrates both the power and limitations of ADR when sovereign immunity is invoked. Another notable case, Fiona Trust and Holding Company versus Privalov, underscores the significance of a pro-arbitration approach in addressing ambiguities within arbitration agreements. This landmark decision by the UK House of Lords established the principle that arbitration clauses should be interpreted broadly and in favor of arbitration. The court emphasized that disputes should generally be resolved through arbitration unless explicitly excluded by the agreement. This case is particularly notable for promoting the autonomy of the arbitration agreement, even when the underlying contract is challenged. But mostly, it really underscores the importance of precise drafting and arbitration clauses to prevent potential enforcement issues. For further cases on enforcement, the ITA Law or Investment Treaty Arbitration Law database serves as a comprehensive resource, offering detailed insights into arbitration precedents and their implications for practitioners navigating complex international disputes. It's an excellent resource for case law and for gaining deeper insights into arbitration precedents.
John, the case studies you've shared are very enlightening. Our audience might wonder what lessons practitioners can learn from high-profile cases like Yukos International versus Russia. What do you think?
Well, they can learn a lot, Walter. For example, Yukos teaches us the importance of respecting procedural rules and anticipating jurisdictional challenges. In that case, procedural violations gave Russia courts grounds to invalidate a very, very large award. Practitioners should always ensure that arbitration agreements comply with local and international standards and anticipate potential sovereign immunity defenses when dealing with nation-state parties. And of course, selecting neutral, arbitration-friendly jurisdictions can also safeguard against such challenges.
These examples really highlight the need for strategic advanced planning in drafting arbitration agreements. Now, let's discuss the future of ADR enforcement. Please turn your attention to box 8 of your help sheet. The Singapore Mediation Convention of 2019 represents a major advancement enabling cross-border enforcement of mediated settlements. This convention offers a less adversarial alternative to arbitration while still retaining enforceability. Digital ADR platforms are also reshaping the field of international ADR, offering faster, more accessible solutions, particularly for smaller disputes. For those interested, the International Mediation Institute, or IMI, website provides detailed insights into these emerging trends. Hybrid mechanisms, such as the Med-Arb, are increasingly gaining traction in the ADR landscape due to their versatility and efficiency. In a Med-Arb process, the parties begin with mediation, where a neutral third party facilitates discussions to help them reach a mutually acceptable resolution. This stage emphasizes collaboration and creative problem solving while preserving relationships between the parties. If the mediation does not result in a settlement, this process seamlessly transitions to arbitration, where the same neutral or a different arbitrator, if agreed, renders a binding decision to resolve the remaining disputes. This two-step approach ensures both flexibility and finality, offering parties the best of both worlds.
Walter, I think our audience might want to know more about how digital ADR platforms are reshaping dispute resolution. What is your take on their impact?
Digital ADR platforms are a game changer, especially for smaller disputes and parties spread across different time zones. They enable virtual hearings, which reduce travel costs and improve accessibility. Platforms like Modria and the IMI's digital tools also streamline case management, making it easier to submit evidence and track progress. For practitioners, adopting these technologies is no longer optional. It's an essential part of staying competitive in the global ADR landscape.
I'd like to add that platforms like Modria and the tools offered by International Mediation Institute are reshaping ADR. Modria provides a streamlined way to manage disputes online with automated workflows and customizable processes that work well for commercial, consumer, and even government cases. It's efficient and scalable, saving both time and money. The IMI plays a huge role in advancing digital ADR. They offer practical toolkits for cross-border mediation, an international mediator directory, and online training resources. These tools not only make mediation more accessible, but also ensure professionalism and efficiency in resolving disputes globally. And MedArb is particularly appealing in complex commercial or cross-border disputes where efficiency, certainty, and the potential for amicable solutions are highly valued. Lastly, resources like the International Council for Commercial Arbitration, or ICCA, and the International Mediation Institute, or IMA, are excellent starting points for further exploration into arbitration and mediation practices, offering valuable tools, guidance, and insights for the practitioner, including many of these new technologies.
Well, this concludes our discussion on ADR international enforcement. We hope this overview has provided you with valuable insights into the frameworks, challenges, and future trends shaping ADR globally.
Thank you for joining us today. We hope that this presentation, along with our help sheet, has provided you with valuable insights and practical guidance. And remember, ADR is constantly evolving, and staying informed and up to date is essential to successfully navigating its complexities.
If you have any questions or need additional resources, please don't hesitate to reach out.